Hello and welcome to TalentSprint. In this session of Polity, we shall discuss about High Courts from Articles 214 to 231. Okay, so moving on to the article number 214, High Courts for the States. Hope you remember article number 124, Constitution of Supreme Court. It is same like and it is similar to article number 214, High Courts for the States. So there shall be a High Court for each state or for two or more states, which shall have a Chief Justice and other judges. Okay, every High Court will have a Chief Justice and other judges. What are the qualifications required for the judge of High Court? So the first qualification is he must be citizen of India. Next is he must serve as an advocate of High Court. For how many years? For 10 years in succession, for either one state or for one or more states. In succession. In succession means continuously. And he must held judicial office for 10 years. Or if he doesn't satisfy the second condition, he must satisfy the third condition. What is that? He must held judicial office for 10 years in the territory of India. The first required condition is citizen of India. And next required is any of the either two, that is served as an advocate for 10 years or held judicial office for 10 years anywhere in India. So moving on to the appointment. Who appoints the judges of High Court? It is not governor. Okay, so president appoints the judges of High Courts. Okay, and also he administers oath to all the judges of High Courts. Don't think governor will appoint, because most of us think because they are the judges of High Court, the governor may appoint. Okay, because they are into the judiciary. I have already told you, judiciary is independent. So for the judges of Supreme Court and the judges of High Court are appointed and administered oath by the President of India. Moving on to the tenure of judges. There is no fixed term of office, but they shall continue as the judges of High Court till they attain 62 years of age. Hope you remember for Supreme Court, it is 65 years. And for High Court, it is 62 years. They can continue up to 62 years. And they can submit their resignation to the President, only to the President. And they can be removed by the President after the recommendation of Parliament. Same like Supreme Court judges. And how is the removal of Supreme High Court judges? So they can be removed by the President after the Parliament should pass a resolution for removal with special majority. What do you mean by special majority? It is 2/3 of the members present in the House. So it is not easy to remove judiciary people. Supreme Court and High Court judges, removal process is same. Okay, and even for CAG and Election Commission, because they must be independent. Politics should not interfere in these bodies. And moving on to the transfer of judges. The President can transfer the judges from one High Court to another High Court after the consultation of Supreme Court Chief Justice of India. Okay, when he consults Chief Justice of India, he can transfer the High Court judges from one High Court to any other High Court in India. Moving on to the types of jurisdiction, almost they are same to the Supreme Court. The first is original jurisdiction, next is writ jurisdiction, next is appellate jurisdiction, and the last is supervisory jurisdiction. But Supreme Court has advisory jurisdiction. President can consult Supreme Court under Article 143. Here there is no article like that. Okay, supervisory jurisdiction. So we shall see what are these. So what is the first one? Original jurisdiction. So the High Court can solve disputes within its jurisdiction only. That means where it operates. Suppose example, Maharashtra High Court cannot interfere in Andhra Pradesh High Court matters, like that. Okay. Every High Court has its own area of operation. So it can solve disputes in its own area of operation. And coming to writ jurisdiction. What are writs? Writs are orders. Whenever the fundamental rights are violated, the Supreme Court can issue writs under Article 32 and High Court can issue under Article 226 for the effective enforcement of the fundamental rights. Whenever fundamental rights are violated, we can approach Supreme Court under Article 32 and High Court under Article 226. They will issue the writs or orders. We have inspired writs or orders from which constitution? Hope you remember. Which constitution? UK constitution. Okay. Next type of jurisdiction is appellate jurisdiction. So what do you mean by appeals? So it can hear appeals from the lower courts judgments, maybe district courts or sessions courts, additional sessions courts in the districts. So it can take up the judgments of the lower courts, which are lower to the high court. And the next is supervisory jurisdiction. So what do you mean by supervisory? It can exercise the power under the high court. Whichever courts are there which are under the high court, it can exercise power over them. It may be any court or any tribunal. Tribunal means special courts for special purpose. Example is CAT, Central Administrative Tribunal. It is a central one. Like we have state administrative tribunals, SAT, SAT. So whichever courts are under the high court can exercise the power on them. So how many high courts are there in India now? Do you have any idea? We have 24 high courts. Don't think 29 states are there. There are 29 high courts and 7 UTs are there. They also have high courts for them for each. So only totally we have 24 high courts for all the 29 states and 7 union territories. This is a very repeated question. 24 high courts till date. Okay. So we shall see only important ones which are important for our examination. That is for our SSC examinations. Because we can't see all of them, all the 24 high courts. It's impossible to remember all of them. We shall see what are those which are very repeated in examinations. So we shall see about them. So first is Bombay High Court. So under Bombay High Court, which are the states and UTs coming? Generally Maharashtra comes under it. Next is Daman Diu, Dadra Nagar Haveli and Goa state. So these are the 4 which are come under Bombay High Court jurisdiction. So they may ask, Daman Diu comes under which High Court? So it's Bombay High Court. So these are the 4 which come under Bombay High Court. Next is Calcutta High Court. So under Calcutta High Court we have West Bengal obviously and also Andaman and Nicobar Islands. Okay. Moving on to the next one, that is Madras High Court. These are the names of the original High Court. We can't say Chennai High Court. Okay. Because these are the names till date. They are not changed till date. Okay. So Madras High Court have the jurisdiction of obviously Tamil Nadu and also the Union Territory Puducherry. These are the 3 courts which are older in India, oldest in India. Bombay, Madras and Calcutta High Courts. Next comes Kerala High Court. So Kerala High Court has Kerala obviously and also the Union Territory Lakshadweep. There may be a question, Lakshadweep comes under the territorial jurisdiction of which High Court? That is Kerala High Court. And next is Govt High Court, which is in Assam. So it takes over the jurisdiction of 7 northeastern states. Okay. Moving on to the next court, that is Delhi High Court. Delhi is the only union territory which has separate High Court. Only union territory to have a separate High Court, that is Delhi High Court at New Delhi. And next is Punjab and Haryana High Court, which has territorial jurisdiction over Punjab, Haryana and the Union Territory Chandigarh. Chandigarh is the capital of both Punjab and Haryana. Okay, so these are the important high courts which are repeated in many examinations. So you have to remember all of these. So how many high courts do we have in India? Totally 24 high courts till date. Okay, and we shall study about subordinate courts. So first is Supreme Court, then high courts, then subordinate to the high courts we have subordinate courts like district courts. So they are mentioned in from articles 233 to 237. So these are the subordinate courts to the high courts. So the qualification required for a district judge. So he must be an advocate or pleader for 7 years. And he must not be holding any central government or state government posts in India. and they are appointed by the governor. All the district judges are appointed by the governor. After the governor consults the high court of that state, and they are also removed by the governor. So district judges will be serving in the subordinate courts, and there will be civil courts, criminal courts in the districts. Then districts are preceded by the high courts, then Supreme Court. So this is all for this session. Hope you have learned about the high courts and subordinate courts. We shall discuss in the students discussion forum if you have any doubts. Okay, hope you are preparing well. All the best. We shall meet in the next session. Thank you so much.